Just to save the time, I will start directly to my topic today. It's functions of law, or better to say, how to search the functions of the legal system. And I will address only two stages. You will see that we could divide this kind of search in different stages, and I will address today only two of these stages. First of all, is it important to discuss concept of the functions of law at all? I would say it is. Even 50 years ago, Joseph Raz has reported that the concept of the functions of law is quite obviously of major importance to any theory of law which attempts the general explanation of the nature of law. That was 50 years ago. Today, the degree of importance of these concepts, as at least to the artifact theory of law, and at least according to some versions of this theory, seems to have been increased from the major importance to the level of essential importance. This statement that the degree of importance increased can be justified if you look in some theorists of the artifact, philosophy of the artifact, who claim basically that there is a necessary connection between the artifact and the function. And I think that this kind of, I wouldn't say return, but reconceptualization of some before views, which are now present in what we call artifact theory of law. And if we accept that there is a necessary link between law and functions, this kind of discourse, of course, brings the question of the functions of law again in the focus. And we can see that because in the last decade we have distinguished legal theorists, and some of them are present here, who basically discuss what is the function of law. And what is interesting for me that we could find different answers to this question. So this is why this question intrigued me, and I thought it would be good to see what are the phases, how to come to the final proposal of what is the function of law. So this kind of presentation of mine is like a route planner. So the good route planner is to make all sequences of the road visible, to present different views, to clarify that there are different views, and to challenge and to detect the challenges on the road. Of course, I will offer some solutions, but some of them are less explained, but some of them I found very important for further discussions, and they are explained in more detail. So the primary goal of this presentation, this paper, is to address what they call axiomatic and methodological phase. Of course, after these two phases, you have to go to the stage of classificatory stage and analytical stage, which means, let's see now, when you have proposed a function that you think that it is the function of law, let's now analyze this. But to come to the final stage, you have to go through all these stages. So in the axiomatic stage, you will see that the problems are the problems of the existence of the function and the problem of what is the function, of using different, of having different meanings for the word function. On the methodological stage, you will see that the central problem is basically the contingency problem, and what is interesting is that artifact theory of law itself brings this problem on stage. So, regarding the axiomatic stage, it is usually taken for granted that that's why it is called axiomatic stage, that artifacts have functions. So in the philosophy of law, you will see that there are some, at least some theories who will say, for example, that the nature of an artifact lies in the proper function, or that one of the defining characteristics of the artifacts is that they have functions. They are for something. So we can conclude that if there is an artifact, of course, that artifact also have a function. And as I said, this kind of idea, I think, triggered some of the legal theories to search now for what is that function of law. It was always searching, but this topic is now the central topic, in my opinion, again. And that the reason is that this artifact theory of law somehow brings this problem, this important feature of the law again on the view. So we have basically two propositions. Classical, every artifact has a function. We have the second proposition that claiming that law is an artifact, so conclusion is that law has a function. Of course, if we cannot find the function of law, or it is not obvious, then something is strange with the law as an artifact. And as I said, I think that this was the reason why legal theorists are now trying to resolve or to identify what is the function of law. So, of course, both propositions can be challenged, and they are challenged, that there are some problems regarding them, and I will try to explain the both challenges of both propositions or address some problems. So, philosophy of artifacts, I will not mention each of the persons of that community who try to discuss, is it really the fact that every artifact have a function? So the discussion can be framed by introducing two counterclaims. Basically, for example, to say there is artifacts have no, or at least some artifacts have no function, or something that is called phantom functions. There are functions, but there are phantom functions. And also, what is important to see if you are claiming that there is a function, of what function do you mean that artifact has? Because there are different meanings of the function. The question is it possible that some products of humans have no function at all, or that people have an illusion of function which in reality does not exist? Let's see the first point. Famous example is a banana in the museum. So for some people this is art, and for other people they don't see anything. Audience, they don't see anything what reminds us on art. Solution that is offered already in legal theory is that to say that at least public artifacts, not being primarily artistic, have the function. If you are satisfied with that answer, we could go to another problem, and that's the problem of the phantom functions. For example, magic wands or feng shui mirror or rabbit's feet are some artifacts that are believed to have a function, for example, to deflect bad chi, which is fundamental force, or to bring good luck, like rabbit's feet, or to produce magic with wands. But in the real world, the question is, this is not the function of the real function of these objects, because it's something that they are thought to be used, but this is not the real function. So the solution could be, okay, let's separate and let's resolve that in the way that we should separate what the thing is really constructed for, from what they represent in the use. But still, even if we take this position, there is a problem if no creator, to go to the law, is at the same time non-user, and he believes that the elimination of or bringing some of this bad luck or good luck is real. The second part of the problems exposed in the problem refers to the concept of the functions. So what do we mean when we say functions? So as you could see, we could talk about real functions, phantom functions. There is also some solutions to resolve the phantom functions problem. Is it really a problem for legal theories or not? we could distinguish actual function as producing actual effects for the purpose of the function. And there is also an obvious answer to this. Okay, most people think that the function is the purpose of the thing, but which is concerned with actual effects. Then we have this important distinction, I think, in my view, between ultimate purposes or ultimate effects, depends on what you consider the function, versus abstractly defined outputs serving different purposes and effects. Even if you are advocating the first, that it is ultimate purposes, then the question arises, okay, but is there only one key output function necessary for appearance of all other possible functions, or a thing like law, for example, have different output functions of equal importance? For example, if you claim that justice and peace are two functions of law, but that that there is no one proper function, for example, peace, and that law, the justice is coming from the peace, or the justice is a function and proper function, and the peace is coming from peace, but there are two separate functions. This is also something that we could find in the literature, in the language, or in discourse of legal theory. And then also, I haven't found this distinction before. We could also make distinction between the function in the narrow sense, because when we say function, we think on the outputs that the thing is producing. The car is to deliver the goods or people. But we also have, and we know that in legal theory, what they called, this is from us, is operative functions. So producing of norms and applying the norms are not these kind of functions that people usually think that when we talk about functions, to think about producing and applying norms. So we could call these operative functions. And I think when we address this problem, for example, what are the functions of law? We could, or there is possibility to focus on operative functions and abstractly define the function of the law. For example, if you have the computer in the Ministry of Justice, and if you have the computer in the Holocaust Museum, the function of the first would be that to detect current local criminals, and the function of the second in the Holocaust Museum could be to remind visitors on the past war crimes. So again, someone could say, but these two computers have the same function, for example, of suppressing undesirable behavior. At the same time, both objects have a function of process of information. So what is the function of this artifact we call computer? One of the approaches to the law could be that the function is usually called, although this function is usually called by theorists to mean final result of the process, sometimes it is useful, at least in some cases, like computer or law, to accept relevance of the meaning of functions as including the operative function, and then to focus only on abstract output proceed to serve in multiple ways. In other words, to say the law is, for example, if something is law, you have operative functions of producing and applying norms, and if it regulates behavior, but not to specify what specifically outputs this kind of system of things producing, not to say it's producing peace, it's producing justice, but to stay only with operative functions and abstractly defined results or outputs delivered by that system. Okay, the second problem in this group of problems is, as I mentioned at the beginning, the problem, or we can challenge that law is an artifact. Someone would say if law is an artifact, it's a strange kind of an artifact. But without going into that discussion, I would stress two implications of the proposition that law is an artifact. The first implication is that we can talk about then of the minimum content of the legal system. When we say function of law, we mean, in my opinion, we mean on the legal function. So it means that it is function that belongs to law. And since the law is consisted of norms, at least of those who conceptualize that law is the legal system, it means it's consisted of norms, that legal functions has to be consisted by legal norms. And if you claim that all legal systems have the same function, this means that some minimum content of legal system has to be the same in all legal systems. So if you say that the function of law is to produce norms, you have to have the norm in all legal systems which says how to produce norms. If you say that the function of law is to apply norms, then you have to have in the legal system the norm which says how to apply norms. You have to have norms in the legal system. That brings us to the minimum content of the legal system. But also what this proposition brings to the light is basically the problem of contingency, and some legal theorists believe that the most important feature of artifacts is their contingency, that different culture may have different concepts of law. So we have now the conflict coming from the same theory, I would say, artifact theory of law. On one side, it comes that law as an artifact has function, and on the other side, you have this thesis, which is also present in the literature referring to artifact theory, that law as an artifact has a contingent content. And this brings us to this problem, which is reflected basically, and we could hear also yesterday, to the methodological problem and clash between essentialism and conventionalism. Depends on how to understand these two camps. And what is important, at least according to some theorists, this clash could resolve if we clarify analytic and folk concept of law. So at the methodological stage, I think we could discuss, it is important, and for example, some theorists Burazin thinks that it is important to distinguish analytical and folk concept of law for the artifact, and in my opinion, especially for the functions. When we talk about analytical concept of law, who uses this concept of law? This is the question of who. Those people who want to find to talk about the nature of law. What is the nature of law? In first line, these are legal theorists, but also legal practitioners can be interested in this kind of analytical concept of law. We could discuss here strong and weak essentialism. In my opinion, we could use what Karl Popper means by essentialism, and this is methodological essentialism, which means that according to this view, only the minimum content of the legal system expressed in this context, it means that it exists independently of any social practice. And it exists, the proponents of this essentialism would say, as an absolute category which have just to be discovered, to discover the category. Okay, this is the strong essentialism. Weak essentialism can be defined as stipulating the content of concepts. We've heard about stipulation yesterday. Stipulating the content of the concepts to stipulate what is the minimum content of the legal system. And these stipulations are, of course, created by humans. They don't exist outside humans, and it's not that it's absolute category out there that should be discovered, but it's creation of humans. But important is to see that they are creating these concepts for some purposes. And the purpose of this concept of law is probably to better understand law, or to law, or rather phenomena, social, natural, or even to use in better way this kind of things. A local and translocal object of research. There is a huge difference whether you do research Croatian legal system, German legal system, or all national legal systems. And what was also mentioned yesterday, but there are also other legal systems, for example, international legal systems. So when I say translocal, there is a difference. The result will be different. What is the object of your research? If you are talking about translocal object, then the results will be different. deductive and inductive method, you could research, for example, comparative constitutional theory would research all the legal systems in the world, 193, and they will say, look, in 990 legal systems there is a norm on rights, so there are norms on rights, so long constitution. In 190 there is a rigid constitution, which means there are norms which say how to change the constitution. In 177 orders you have the norms on judicial review. But this is inductive method, and you could group them in that way. Deductive method, and what we, I think, legal theorists also do, is to stipulate the conception, to say there are constitutionalized and non-constitutionalized legal order. I have never heard that constitutional legal theorists use these terms, but in legal theory it's something that is usual, and I think it's very useful tool to make the difference between constitutionalized and deconstitutionalized legal order. So these kind of concepts are produced by one legal theorist, Bastini, probably by looking for also having in view different systems, but also using some conceptual exercises, like, for example, the property of the norm. And he stipulated this is the division, constitutionalist and deconstitutionalist. Now, of course, this is the deductive method, it's not inductive, but of course that it can be also checked by referring to the real legal systems. Theoretical and practical purposes. Regarding the fork concept of law, which are, at the moment it's on opposite side, but I think it's not on opposite side, it can be synthesized. It can be put together, this analytical fork concept. We know that this kind of view appeared in legal theory, Jackson, and later on people use it, but what is the important? Usually people use this concept to refer to ordinary people language, okay, to citizens. What citizens think that the law, what students think that the law is. And in my opinion, it's even better to, this is a good view, and it helps us to distinguish what legal theorists think that the law is, or conceptualized, and to what norm users think that the law is. But norm users can be also the legal professionals and citizens, and what we could see that legal professionals and citizens, ordinary people, could have different views on what is the law. In any case, focus on fork concept, and this is the Gestalt switch in legal theory, focuses us on norm users and not only on legal theorists or on those who create or stipulate this kind of theories of what is the law. Also, this focus brings us, make us aware that legal concepts depend on the human mind. It's not that they exist in nature. What also this kind of using fork concept brings to the stage is the contingency thesis again. So this thesis, if you read the theories on artifact theory of law, can be separated in two. The first thesis is not problematic. It says only that that appearance of law is contingent. It means that it can exist and it can stop to exist. If there is no concept of law in minds of some people, artifact of law will not exist to say. The second part refers to the content of law, contingency of the content of law. And we could say that we have Greek contingency thesis, where we could say, okay, of course that the most of the content of legal systems is contingent. We could have this kind of sanction or that kind of sanction, and this kind of behavior, that kind of behavior. But some minimum content of the legal system should exist. The strong contingency thesis, and this is the most problematic for artifact theory of law, claims that to shorten all this discussion, law is whatever people identify and treat through the social practices law, tamana. At the end, I don't know if what is my time frame, but what we could try with these two concepts, analytical concept and flow concept is to think about, okay, we're talking about artifacts. What is the best place to place the artifacts? The best place to place artifacts is in museum. And we could make this mental experiment basically to try to think about museum of law. So to have the museum of law, it's some kind of project, and as kind of project, you have to have directors. And probably these directors have some purposes of that museum. So the first step is to declare what are the purposes of talking about artifacts and to talking about the artifact of law. Then the classification is important for museum and museums, especially the Museum of Law, to see what to put on which shelf. What is on one shelf, what is in another, what is outside of that museum. You need classification in museums, and you need classification in legal theory. Then it's possible to make synthesis of insights, analytical and flow concept. And at the end, it's possible, as director of that museum, to respond to contingency problem. And also depends on the purposes again. And the response could be, okay, we have this purpose to when we decide what objects will be in that museum, we use scientific methods. We think that there is a scientific nature of the theory proposed, and that means that it should be false. The possibility of falsification should be there, so you cannot claim something and not have possibility to refute, to clash that theory and to prove that it is wrong theory. If you have this kind of theories, they are not scientific. Or the response can be from using historical approach or genealogical approach to concept, which means to explore what is the concept of, for example, Kelsen, what is the concept of flow a few centuries ago, how it develops, and to claim, like Kelsen did, that the verb is a sanction. And this is an important element of his theory of law. And then what he did, he presents different historical documents, which shows that, I don't know, Roman people, they claim that and keep and think that the verb is a sanction. So this is also the possibility how to respond to this strong contingency thesis.